Bienvenue à la réunion numéro 26 du Comité permanent de l'accès à l'information, de la protection des renseignements personnels et de l'éthique de la Chambre de communes. Pursuant to Standing Order 111.1, the motion adopted by the committee on Thursday, June 9th, 2022, the committee commenced consideration of the certificate of nomination of Philip Dufresne to the position of Privacy Commissioner referred to the committee on Wednesday, June 8th, 2022. So I would now like to welcome our witness and congratulate him on his nomination and turn over the floor to him for up to 5 minutes for an opening statement.
Thank you, Mr. Chair, members of the committee. It's a great honor and privilege for me to appear before you today to discuss my qualifications and competencies to perform the important role of Privacy Commissioner of Canada. And I take this opportunity to thank you for all the work that you do as parliamentarians in legislating, deliberating, and holding the government to account. I would start by saying that my professional life has been dedicated to the strengthening of Canada's public institutions and to the protection and promotion of the fundamental rights of Canadians. J'ai œuvré en ce sens pendant 15 ans.
I have done this for 15 years in the context of human rights at the Canadian Human Rights Commission. I've done it for the past 7 years in the context of constitutional and administrative law as the law clerk and parliamentary counsel at the House of Commons, and if appointed, I would continue to do so as Privacy Commissioner of Canada. Prior to my appointment as law clerk of the House in 2015, I was the Canadian Human Rights Commission Senior General Counsel, responsible for the Commission's legal and operational activities pursuant to the Canadian Human Rights Act, the Employment Equity Act, as well as the Access to Information and Privacy Acts.
Lead counsel for the Commission in the landmark First Nations child welfare case before the Canadian Human Rights Tribunal, which led to the largest settlement of its kind in Canadian history. Prior to this, I was lead counsel in the House of Commons and Vade case before the Supreme Court of Canada, which remains the leading case on parliamentary privilege in Canadian law today. In addition to the Vade case, I've appeared before the Supreme Court on 14 occasions in cases raising issues such as the separation of powers, the impartiality of tribunals, the accommodation of persons with disabilities, freedom of expression, and the balancing of national security and human rights. My experience at the Commission has a number of direct correlations with the role of Privacy Commissioner. It involved the promotion and protection of fundamental rights and the investigation of complaints in an expeditious and procedurally fair manner. It required the appropriate balancing of fundamental rights with public interest considerations and the ability to explain complex concepts in a plain language and accessible manner. It also involved working with the public and private sectors to find constructive solutions, building a culture of rights, considering international norms and comparators, and working with provincial counterparts. Dans mon rôle actuel,
In my current role as a law clerk of the House, I'm the Chief Legal Officer of the House and lead the office responsible for the provision of legal and legislative services to the House and its members. I've successfully defended the House's privileges in the Boulris v. Board of Internal Economy case and led the legal team representing the Speaker of the House in the context of a judicial review application brought last year with respect to the House's power to compel the production of documents. I've been tasked by multiple committees to interpret and apply privacy law principles, most recently in reviewing proposed redactions made to documents that were requested by committees in the conduct of their studies.
Of codes and policies to prevent harassment on the Hill and to ensure an inclusive and safe environment for members of Parliament and staff. I was proud to be the House Administration's diversity and inclusion champion for the last 5 years. Throughout my career, I've always placed the utmost importance on public service and on giving back to my community and my profession. Ainsi, j'ai occupé divers.
As such, I have served in various capacities of the Canadian Bar Association, including as president of the Constitutional Law Section and executive board member of the Quebec branch. I have also served as president of the International Commission of Jurists, Canada, an institution that promotes judicial independence in Canada and internationally. I believe in the importance of education and mentoring, and having been a part-time professor in law faculties and continue to serve as a judge in the Laskin Bilingual Administrative Law Mooting Competition. In all my roles, I have been guided by the values of balance, impartiality, fairness, excellence, the rule of law, the public interest, and respect for the democratic and legislative processes. Those are the values that, if appointed, I propose to bring to the office of the Privacy Commissioner of Canada.
I believe that I would bring to the role of Privacy Commissioner a vast and unique array of experiences and knowledge, as well as the unwavering belief that Canadians' fundamental privacy rights require strong advocacy, protection, promotion, and education on an ongoing basis. As Privacy Commissioner, my vision would be privacy as a fundamental right, privacy in support of the public interest and of Canada's innovation and competitiveness, and privacy as an accelerator of Canadians' trust in their institutions and in the digital economy. En terminant, je souhaite...
In closing, I would like to take this opportunity to thank Daniel Thérien for his outstanding service and leadership these last 8 years as Commissioner. I have been impressed with all of the great work done by the OPC team during his mandate, and if appointed, I look forward to working with this dedicated group of committed professionals in protecting and promoting the privacy rights of Canadians. I am happy to answer your questions.
Thank you very much, and to begin, we have Mr. Bazan for up to 6 minutes.
Thank you, Mr. Chair, and I want to congratulate Commissioner Dufresne on his appointment. You've always proven yourself to be a person of integrity and highly professional, and looking forward to working with you in this new role. I want to just go over some of the highlights of your time as law clerk to the House of Commons, and the work that you did specifically with the Canada-China Special Committee that studied the Winnipeg lab leaks, and the case of parliamentary privilege that you actually argued on behalf of Parliament. Can you talk about that in the context of the Privacy Act? Can you talk about that as to parliamentary privilege and the supremacy of Parliament, as well as the committees that you're before right now and the work that we do?
Thank you. So I think the cases on parliamentary privilege and my work as law clerk have shown that courts have recognized rightly the fundamental role of Parliament, the fundamental role of the House and its committees, and the need for the House and committees to have the ability, to have the powers to do their work, and to do so in cases covered by privilege in an autonomous way that's not going to be subject to review elsewhere. At the same time, I've always advocated to the House and committees that having this authority, this power, is something that ought to be exercised responsibly and having regard to public interest consideration, turning your mind to this. And I think in the context of privacy, there's similar aspects there where I firmly believe privacy to be a fundamental right and it has to be protected. At the same time, I don't see privacy as being opposed to the public interest or to innovation. And so you can have both, you need to have both, and as Commissioner, I would work towards that goal.
Thank you. So, as you know, the Public Health Agency of Canada President Ian Stewart at the time was refused to table those documents and was called before the bar in the House of Commons to be admonished by the Speaker. Do you believe that was an appropriate and consistent way of dealing with that individual, as well as protecting the integrity of Parliament?
The assessment of the appropriateness of House decisions or House committees, I would leave to the House to make. What I've said to committees is the committees have the authority. They have the authority. The House has the authority to request documents, and when they don't receive those documents, the House has certain powers, which would include taking steps as it has done in this case, but it is up to the House and it's up to committees to decide. It's not going to be always going to be appropriate, and that's a decision, and that's what privilege recognizes, that is a decision for the House to make.
So because the government refused to hand over those documents and that...
Point of order, Mr. Chair.
Make sure you stop the clock.
Yes, the clock is stopped. Yes, Ms. Khalid, you have
I'm just
point of order.
questioning the relevance of this line of questioning. I mean, Monsieur Dufresne is here as the Privacy Commissioner. I'm not sure why we're questioning him with respect to his role as law clerk.
I think that's precisely the purpose of the meeting, is to review the CV and the background and professional background of the candidates. So I would... I mean, yes, we always need to make sure that our questions are relevant, but I think that's the purpose of the meeting today. Go ahead.
Thank you, Mr. Speaker. And Mr. Chair, and before you turn on the clock, I'll just, in rebuttal to that point of order, is at this point of order, this committee is definitely on the issue of looking at the credentials, the experience, and the background of a government appointee. That's the reason why we're having this committee meeting under the standing orders.
Thank you, Mr. Bazan. I've ruled on it, and I think that'll be enough, and we can.
Okay, I'll continue on.
And your clock is running.
Going back on this is that the government took the unprecedented move of refusing to hand over the documents, and then ultimately challenged or threatened to take Parliament, the House of Commons, to the Supreme Court of Canada. And as law clerk and as parliamentary counsel to the House of Commons, you would have been in the position to make the argument in front of the Supreme Court. So if it hadn't been for the election, were you already in preparations for that, and how would you have argued the case to protect the supremacy of Parliament?
Well, in representing the Speaker of the House in this matter, we we did in fact file written submissions to the federal court, and we took the position in that case that the House had the authority to do what it did, and that authority had not been limited by the adoption of the Canada Evidence Act. And so that matter has been discontinued following the dissolution of the House. So that's where it went in terms of the court process.
Although the House was dissolved at that time and that Parliament came to an end, do you believe that is still considered a breach of privilege of the Parliament of Canada, and that should still be dealt with down the road? Does it undermine the constitutional validity of the House of Commons?
Well, I think that in this matter, the House made its decision. There was a challenge that was brought, and the House and Speaker made a ruling and filed legal representations in court, setting out what I, as law clerk, took to be the proper legal view, which is that the House had the legal authority to do what it did, and it had not been constrained by the Canada Evidence Act.
Thank you. And Commissioner, in your new role, as you look ahead, and you and I were chatting before committee and talking about the new technologies, the work that this committee is already undertaking under mobility data, under facial recognition, artificial intelligence, how do you view your role as it relates to modernizing current legislation, regulations, and keeping up with the changing times and how that impacts Canadians' privacy?
This is a very important time for privacy, and this was one of the many reasons why I was interested in being commissioner. There needs to be a modernization of the two fundamental privacy laws, the Privacy Act and PIPEDA, and so parliamentarians will have a role to play. The commissioner will have a role to play, and stakeholders and industry as well. But this is a priority. As commissioner, I look forward to putting forward the values that I've set out here today in comments with respect to potential new legislation tabled in the House. Outreach is very important to me. I believe that Canadians need more information about privacy. Commissioner Terrien did great work in that respect, and I look forward to continuing that. The report that this committee has issued on mobility is a good example of a document that can serve to educate and to explain those concepts that are complex concepts, but that touch literally everyone. And so this is something I would be working towards.
Thank you. And now for up to 6 minutes, Mr. Fergus.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. First, I would like to congratulate and welcome Mr. Dufresne. I have been following your career with a lot of interest for many years. I can't think of a better person or a better qualified person for this position, which is a very important and central one for Canadians. I have a few questions for you. My colleague, Mr. Bazan, spoke about your previous career as law clerk in the House of Commons. I'd like to focus on your experience on the Human Rights Commission. In what way do you think that role served you as and was beneficial to the role as Privacy Commissioner? Thank you, Mr. Fergus. I think this role guided me and trained me well, there are many similarities between both jobs. First, we're talking about fundamental rights, which must be protected for Canadians, and they have to be interpreted in a very strong but global way. But we're also talking about a law that has to be interpreted in real life by taking into consideration public interest, its impact, and also we have to make sure that there is a better understanding of that law, both for Canadians but also with industries and the government. I had to use many different tools in order to reach the goals, which are to protect fundamental rights. So the tools could be education, to interact and to make sure that we agree ahead of time, make sure that there are policies in place to be able to make complaints, for example, or legal decisions. But I do think that in this period where technology is changing so much, we really do have to consider all of those changes. There are also proactive technologies. For example, I talked about wage equity, and we came up with a compensation for that were enormous for victims of discrimination. Now there's a new law on wage equity, which is a lot more proactive. I think that that combination of proactivity and complaint system based on a rights model are similarities that helped me a lot.
Nos supérieurs, y compris la Cour.
I think that also there are ways to fight for Canadians. Thank you. You mentioned the following. There's a certain rule that exists. It's there not only to determine the rights of privacy or private life, and also the roles of the government. I'm sure that when you got the call that your candidacy was being suggested, I'm sure that you imagined yourself in the role and occupying the position. Did you think of the scope of your responsibilities with regards not only to Canadians' privacy as related to their government, but also in the private sector? This is a period where people's privacy, according to many or according to some, is threatened by software, by companies who are monetizing and capitalizing. Perhaps that's not the word that I'm looking for, but I would say monetize the people's private data, personal data. How do you see your role? Thank you for the question. It's fundamental. In one of my previous questions, I did say that privacy touches everyone, younger people, elderly, people who are fascinated by technology, and those who aren't. There's a lot of potential and innovation and participation that's possible. However, there are risks. It's important to be able to have privacy laws for the private industry. The role of the commissioner, if I am appointment, would be to warn the government or advise the government for the next iteration of C11 when it is presented to Parliament, because it starts with this bill. It will touch on a lot of reports, a lot of points made in your report. It's also a role where I would be interacting with the Canadian population, but also with private industry. I would also have exchanges with the private industry to see what their preoccupations are and what their realities are. It's important that the bill be practical and that Canadians understand that they can opt out or refuse, but we also want to make it easier for the industry and for them to understand what they have to do. So there is a certain role with regards to practical codes.
It is time now to go to Monsieur
C'est vraiment
Villeneuve.
dommage, mais merci beaucoup, monsieur.
Thank you very much.
Monsieur.
Mon collègue, M. Fergus, soit rassuré, on va quand même poursuivre dans une ligne similaire.
I will go in the same vein. Congratulations for your nomination. Very happy to see you here today. I'd like to talk about a few different things. Many Canadian citizens find that they are under surveillance, and they find that maybe this surveillance has an impact and ruins their confidence in institutions. What do you think of that? As discussed in front of this committee, it is important to have a plan that is not exclusively based on consent. It's not only the citizens' responsibility to inform themselves and to understand the clauses which are often very complex and to say yes or no. We have to reassure Canadians. I did speak about confidence earlier and trust. We have to have a legal plan that will frame certain practices that will not be permitted even with consent, or some that will be without consent. There's this element of transparency that is important. We must have proactive approaches with private industries and the government. We should have privacy by design, for example. We need better communication of those clauses. Canadians must understand really what is happening. Sometimes those concerns are valid, and sometimes they come from the fact that we don't understand what is happening. And that can create distrust. Your work recently on mobility was on communication, on what had been done, and on data that had been collected, and so you looked at what that had been used for. There was a very important case against Tim Hortons that brought that to light. So I do think that there is a lot to do on the legal front, but also with communication and education. Past elements showed us that companies are creative, but there are things that we will people will always say certain things are legal, but unethical. But how will we adapt to a market that is constantly moving? I think we have to have continuous exchanges with industries, but also with academics, citizens, the parliamentary people. But with regard to ethics, we should look at whether or not it should continue to be legal, or should the legal framework intervene. I said this at the Human Rights Commission. Sometimes I had interactions with leaders who had good intentions, but there are legal frameworks in certain sectors where you might hope for certain things, but it's not compulsory legally, and so people will then prioritize. That's why we have to incite people to do the right thing. And, by calling them old dogs, it's not realistic to say that companies will prioritize what they should when they do versus when they do have a legal framework. So you're requesting something clear, indeed. With regards to the mobility report that we presented recently, we talked to Commissioner Terrien. He said he was consulted but had not been involved with that study. The role of commissioner allows citizens to trust the government. What do you think when the government itself does not consult its own commissioner in these kinds of cases? With the exchanges you had with Commissioner Terrien, he did say that he offered those services and the government chose to use their own experts. I do think that Commissioner Therrien admitted that it was legitimate for the government to do that and that he was not necessarily needed. But with regards to trust, I do think that that created some doubt. The government did go for internal advice and is that as independent as external advice. And I think that that's where the commissioner comes in. I think that is a recommendation you've made. You've talked about making proactive audits in order to go verify what's happening. And that would allow for validation in terms of what the government is doing. And I think that is useful. Well, do you think that that was done by lack of credibility of the commissioner, that they chose not to consult with the commissioner? I would hesitate to speculate on that because I was not involved with that at all. With regards to the impact, which was discussed in this committee, we did see many people saying that it is preferable if the commissioner can play that role. So there were indeed recommendations in that vein. With regards to educating people with regards to privacy, because it is still vague with citizens, what can the commissioner do? One of the recommendations made is the privacy law, which exists within PIPEDA. I do think there are many tools that are available. We have to be creative. The commissioner has a lot of excellent documentation. I do think we could look at a model that is, for high school and not necessarily with practitioners. I do think that the government is working on that.
For up to 6 minutes.
Thank you very much, Mr. Chair. And I'm going to begin with actually stating a little bit of my disappointment with having Mr. Dufresne here today before us for this appointment, only in so much as I didn't have a chance in my very short time to really pick his brain as the law clerk, who is obviously very capable and well respected around the table. Now will be changing roles into this position. And so I just want to first thank you for your incredible public service under that role. And I know I had a very brief privilege to see you before the Emergency Act Review Committee, in which you provided us sage advice with a duty of candor that I expect you'll carry on in your role as commissioner. My friend, Mr. Fergus, referenced your time at the Human Rights Commission. And I'm wondering if you can talk, because I heard you say that you called it a fundamental right. So can you just begin by expanding on why you believe privacy is a fundamental right for Canadians, and how, as the commissioner, will you bring a rights-based approach to your work within the Privacy Commission?
Thank you, Mr. Green, and thank you for your role in the Emergencies Committee as well. It was a privilege to appear before you in this capacity. I think that human rights and privacy rights are fundamental. Privacy rights have been recognized in the Universal Declaration of Human Rights at the same time as we had a major recognition of human rights. They deal with aspects that are of fundamental importance. And again, this was recognized as far back in 1948, fundamental importance for individuals. And to have a need that this be protected from actions of the state. And that was the focus in the declaration. We see now in the context of privacy, it's not just vis-a-vis the state, but it's also vis-a-vis the market, and we've used the word surveillance capitalism. And so privacy has been recognized by the Supreme Court as being a fundamental value in a modern democratic state in the DAG matter, talking about being grounded in physical and moral autonomy and the freedom to engage in one's thoughts and actions and decisions. So I think if this was true in 1948, it was true in 1997 in the DAG case, it's certainly true today, where we see even more potential for privacy and information being shared, being collected, being obtained without individuals knowing. So it is something that I will be, in my role, should I become commissioner, I would be advocating very strongly for that, and it has been done by Commissioner Therrien. I will certainly continue to do that, and I hope and like to think that I will bring credibility as a human rights practitioner in doing so.
And you referenced PIPEDA, the Personal Information Protection in Electronic Documents Act. Obviously, there's the Privacy Act as well. How do you see your role in providing advice to the Parliament on those bills?
I see the role in providing advice in appearing before this committee, in publishing opinions and recommendations, in engaging with officials, with parliamentarians, with academia. I think one of the discussions that I've seen in the OPC is a greater outreach, perhaps broader outreach with academia, with practitioners, with citizens, with industry, private, public sector. And so I see a very important role there, but certainly deciding what will be in the modernized PIPEDA and in the modernized Privacy Act is, of course, a prerogative of Parliament. And so it will be for yourselves, this committee, and ultimately the House. But as Commissioner, I will certainly be doing everything to provide you with my best advice in the circumstances and ensuring that the new bill that becomes law is rights-based, makes sense for Canadians to trust and participate in the digital economy and to have trust in their institutions.
And so moving forward, I'm sure you've given this a lot of thought. What are going to be your main priorities during your tenure?
Well, I think my main priorities are going to ensure that Canadians can have a better understanding and better protection. I think the private sector law has expectations that may come first. Certainly it did with Bill C-11. I think it would be a priority to ensure that Canadians can participate in the digital economy, that Canada's market...
Do you have more comment on C-11? I'm glad you brought that up because it's certainly one that we seem to have gotten bogged down on. And I'm just wondering if you would share any perspectives on C-11.
I think that a lot of the comments that have been made by the Commissioner and by this committee in terms of looking at de-identified information, looking at a rights-based model, looking at increased powers for the Privacy Commissioner in terms of order-making powers, looking at penalties and the regime therefore. Those are important things. Looking at consent and calibrating, making sure that consent is meaningful, looking at proportionality and necessity, and ensuring that certain purposes and certain uses are defined as either not being allowed or being allowed without consent, but in appropriate cases. And so those are opportunities, again, aligning it, looking at the international sector, the GDPR, what's happening in Quebec, Bill 64, ensuring that this interoperability, ensuring that we can deal with the private sector and the public sector in a way that's consistent. And we've seen in terms of your study on mobility, the public-private partnerships. We see that more and more. And so how do you ensure that there is more harmony, that the government can't contract out by using private sector firms, and that it's the same protection everywhere?
Thank you.
Thank you. And
Thank you very much.
Now for up to 5 minutes, Mr. Williams.
Thank you very much, Mr. Chair, and through you, and to echo our sentiments from our rest of our colleagues. It sounds like we have the right person in the role, and thank you very much for coming today. I just wanted to get a little bit more into the old C-11, and just privacy obviously is a lot harder to protect these days because it is digital. So you mentioned looking at consent, proportionality, GDPR. Is there anything else you've seen in your work as a law clerk on the assessment of the old C-11, how effective it is? And do you see that being modeling the GDPR model from Europe at this point?
Well, I think some of the concerns that were raised, and I think there've been lots of comments made by the OPC, including recently to this committee, in terms of commenting, not necessarily looking back to C11, but anticipating in terms of the new iteration, what should some of those elements be. And so I think looking at the first one being rights-based framework. So making sure that this is a regime that is not exclusively based on consent and that recognizes privacy as a fundamental right. Dealing with the de-identified information, very, very important, ensuring that there are prohibitions on re-identification and calibrating, making sure that it doesn't fall outside of the law. Dealing with automated decisions, artificial intelligence, all of these new things that weren't present. There were some discussions on C11 in terms of whether you needed a tribunal to review the commissioner's decisions in terms of penalties, and the OPC took the position that that should not be, that it should be a final decision of the OPC subject to a judicial review. And so I think this is going to be important to look at. I share the concerns in terms of delays. If you add layers of review that just make it longer before you have a final resolution, I share the concerns with the federal commissioner having perhaps less authority than provincial counterparts. But there were some other options that were raised in this discussion as to whether there could then be a direct appeal to the Federal Court of Appeal or a specialized tribunal. But I think the key point is to ensure that the OPC is able to operate within that regime effectively. There's been discussions in terms of resources. There's a concern that was raised in terms of the new powers or responsibilities for the commissioner to verify codes of practice. And the commissioner, I think, rightly raised the fact that if that's the case, there may need to be some discretion in terms of where you focus that work, because otherwise it can very quickly take a lot of your resources. And this is something that I did at the Human Rights Commission, was to adopt a public interest litigation, strategic litigation approach where we would focus our key resources on the key cases that would have the biggest impact for Canadians, and that has been very successful.
And that sounds great. I think, the biggest criticisms of C11 in the past were its ability to stifle innovation as much as protect it. You said earlier to Mr. Bazan that privacy is not opposed to innovation and we can have both. So how do you think we can have both? And what do you think is appropriate balance of privacy and innovation?
Well, I think I would say for the same reason I don't see human rights as being stifling innovation or the public interest. These are things that can coexist, and it requires collaboration. It may require better understanding, better communication. But I see it as coexisting in the sense that privacy rights that are strong and that are well known and that are practical are going to generate trust in Canadians to be participating in the digital economy, which is going to be good for industry. It's going to create trust and credibility for Canadian economy and industry vis-a-vis counterparts in Europe and other markets, and it's going to generally send the message that this is supportive of trade and commerce. And so I do not see those as being opposed.
Thank you very much, sir. And you did talk about the expansion of roles. What do you see the Office of the Privacy Commissioner playing in terms of Privacy Act and PIPEDA? One of my main questions is, do these pieces of legislation need real teeth? So strong enforceable penalties to be effective?
I do, and I think I was talking about incentives. I think incentives are important. The existence of these powers and these penalties, you hope not to use them, but the fact that they exist, I feel gives greater impact in terms of the views and the positions that are expressed by the OPC, and gives greater incentives in terms of compliance and also in terms of delay. If what you have is a recommendation that then is considered and then can be made into an order later on if there's an application to the court, this really adds time to the process. And so I think we are seeing a trend.
And last question, sir. Do you believe your office should be the one enforcing these penalties?
Well, it'll have to be a yes or no because we're out of time.
Yes or no?
That's up to Parliament, but I will act accordingly.
Thank you.
Ms. Khalid for up to 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Dufresne, for coming in today. We really appreciate you putting your name forward. So maybe I'll start by asking, having the experience of a law clerk and sitting in Parliament and watching the proceedings happen, it put you in a very unique role to understand and to although you were more of a reactive in terms of the actions that you had to take, in this role as a privacy commissioner, do you see yourself being more proactive on the issues that you've outlined as priorities, or would you, we hear that there's a lot of complaints that come to the privacy commissioner's office, and how would you manage resources to be more proactive if that's the case?
Thank you. And I think that for me, the role of privacy commissioner is in a way a combination of my experience as a human rights lawyer for the Commission and as counsel for the House. I think there's an important role in understanding parliamentarians and understanding legislators and understanding laws, and also the ability of working with multiple parties, members from all parties with different interests, and being able to balance that and to understand that. In terms of proactivity, I think as Privacy Commissioner, I would be more proactive in terms of expressing views in terms of what legislation should be. As law clerk, I would not typically do that. I would be focusing more in terms of the rights and privileges of parliamentarians. But as Commissioner, I would view the role absolutely as being proactive in terms of promoting, protecting, expressing views, and in terms of the complaints process, ensuring that it is used as effectively as possible. And so talking about strategic use, focusing on big cases, ensuring that the resources are used as well as they can, and then ensuring that there is that discretion for the Commission to have that greatest impact. That's not to say that individual cases are not important. They are. You have to focus on them, but there's a way of doing both.
Thank you. And, we've talked a lot about privacy and the digital era, and I think you would be remiss if we didn't also talk about the other side of that coin, and that is the era of disinformation. Do you see yourself as a privacy commissioner having a role in kind of combating that disinformation that is spread throughout not only public but also in the private sectors?
I do. I think it's incumbent on public officials. Certainly, I would see that for agents of Parliament, and I saw that as the Commission as being important to express views, to correct the record if there are misstatements being made. I think in those roles there, and it's absolutely essential, of course, to be always fair with the facts. But there is a lot of credibility that comes with such positions, and I believe it should be used not only to make findings if there's a finding against the government, but if there's a finding to be made in favor of the government, to highlight or industry, to highlight that something was done in the proper way. Here's why. That is also part of generating trust, to show that, and this was, I think, consistent with the idea of having proactive audits, to say that will bring reassurance. It's not the goal is not to go in there and necessarily to blame or find fault, but to go in and work collaboratively, find solutions, and if there is fault to find and there is resistance and there needs to be that ultimate complaint, so be it. But there's real opportunity as well to highlight. I think when it is done properly, I think it's important for Canadians to hear that and to hear it from officials.
Thank you. And I wonder, we are currently studying facial recognition technologies, and we've heard from a number of witnesses that a moratorium on the use of facial recognition technologies is necessary in order to for the government to go forward and protect Canadians' privacy rights. Now, I wonder what your views are on a moratorium, whether you think it's actually possible, and whether you think that we'd be able to, as government, be able to keep up with protecting the privacy of Canadians by way of a moratorium.
I think that there may be situations where it's appropriate, and I think what's important is to have a regime and to have guidelines. And I think that's what you've heard from the Privacy Commissioner Thérien and others in terms, and there was a joint framework that was issued, I believe, on June 2nd, in terms of until there is legislation, here's how it should be done in terms of proportionality, necessity, minimal intrusion, using it in appropriate cases. So that is a good document. That's a good starting point in terms of how do we deal with the situation now. But there is also a strong call for having a framework.
Very much so.
Thank you. Now, Monsieur Villemur pour 2 minutes et demie.
Mr. Villemur for 2.5 minutes. Thank you. Many companies, of course, want the law to be clearer so that they know what they can do. Of course, they say that there's an economic factor and that they won't be able to actually do business. For one of our neighbors, the legislation is pretty minimal. What is the capacity for companies to self-regulate? The issue with self-regulation, once again, is a question of incentives. There are sectors that are regulated, and we have seen situations where there has either been problematic use or problems with regards to the perception of these laws. And so with regards to self-regulation, we can't just trust blindly. There are clearer directives needed for Canadians. I do think that it's a reality that for all of us, it touches everyone. So there are examples like Tim Hortons, Facebook, Clearview AI. There are many examples that show us that we do need better planning.
Vous avez parlé beaucoup de confiance. Et
We talk about trust, which we find in conformity. Do we find it only in conformity, or how would you define trust? I do think that comes from having a clear legal system which Canadians can refer to, where Canadians can say, I'm not responsible, and the responsibility is not falling upon me to protect myself against this new world. The system, of course, with the commissioner, there are some fundamental elements for which we need protection. Companies must know how the system is made. There's privacy by design. We talk about privacy culture. Companies are setting up these systems that are transparent and communication is clear. There are more proactive obligations as well. And that's where we are a lot closer to a privacy.
Green for up to 2.5 minutes.
Thank you very much. So, you're going to be putting together a plan for your department. You're going to be, taking steps to pick up wherever Mr. Thérien left off. And I'm wondering, in doing that planning, what do you see as being your biggest challenges?
Thank you. I of course, very much look forward to meeting the team and to speaking with all the colleagues. And I've looked at the DPR. I think some of the things that are top of mind is the fact that there, with the extension order for the Privacy Act in July, there will be an influx of new cases with the expansion of the mandate. And so that is something that I know the Commissioner has asked for additional funding. So that's going to be something to follow up on. And also has been stated that if the new PIPEDA is modeled on the C11, and hopefully with the improvements based on a lot of the comments that were made, that too would require, I think the Commissioner Thérien mentioned, a doubling of the resources. So these are going to be some of the immediate discussions that I have with the team, specifically in terms of the order-making power and looking at what kind of structure is needed. Commissioner Thérien talked about adjudicators and so on. So these are some of the elements, and making sure that the office is prepared to advise Parliament when this legislation comes, this bill comes.
And what about in a longer-term horizon?
Longer term,
what do you see coming down, like with technology where it's at, and the way in which it seems like our legislation gets left in the dust whenever there's a new transformation, under Moore's law? Like what do you see as our long-term challenges for your
I think long-term challenges are focusing on all of the digital innovations that we're seeing and making sure that we have, there's the legal framework, but that the OPC also has the internal expertise to provide good advice on that in terms of codes of conduct. There's been some discussions on de-identification and the prevention of re-identification. So what is appropriate? How do you accept? What kind of mechanisms do you need to put in place so that that de-identification is accepted as such and that you are minimizing the risk of re-identification? So this is fundamentally important to ensure that there is that framework. Artificial intelligence, more and more these decisions being made by these algorithms using information. So how do you address that? And there were some elements in the GDPR and in C11 in terms of algorithmic transparency and understanding how those decisions are made, and ideally being able to challenge those decisions. And from a human rights standpoint, there were concerns raised there in terms of profiling. And so how do you deal with this technology that is at an accelerating pace? So I think this is one of the challenges. The technology is accelerating very, very quickly. Legal amendments, not as quickly. And so
thank you, Mr. Dufresne. We're a little over, quite a bit over time.
He's
again.
as excited as I am. It looks like.
Yes.
Do we have another round, Mr. Chair?
I have Ms. Gallant, followed by Ms. Hefner, and that would take us to the end of 2 full rounds. We do have additional time if other members would like to, we may have time for another question, but my intention had been to complete the second round, and we'll see if we may have a motion at that point on the issue of the nomination. So with that, I'll go to Ms. Gallant.
Thank you, Mr. Chairman, and through you. Often we find out about a breach in privacy after the fact. For example, the metadata from people's phones that Health Canada purchased from cell carriers to justify the cruel and inhumane lockdowns we suffered through. Do you see your role as Privacy Commissioner to require the telecoms and web giants, for example, to obtain pre-approval of metadata from your office before implementing or using or selling the information?
Right. And I think this was one of the recommendations in terms of either proactive audits or making sure when you're dealing with this type of metadata or location tracking. It was discussed in this committee in the context of the government, but also in terms of third party, making sure that individuals are aware. What is the information that is going to be collected? Why is it going to be collected? What use? What's the purpose? And also to constrain with who is it going to be shared, if any. And so there were concerns there in terms of keeping it even within government, within that department, if you're going to share with other departments. So how do you proactively provide that information? I think that's one of the elements where oftentimes the information may be there, but the onus is on the individuals to do a lot of digging to find it. And I think one of the themes that came out in your report, and I agree, is to make it as user-friendly as possible. Make it simple, make it easy to opt out, make it easy to know what is happening.
So you don't believe, though, that it should receive your approval prior to being implemented unless it has the easy opt-in and opt-out?
I'm not sure that it would be necessarily realistic that the OPC in every single case provide approval, but there may be certain cases where it is required, and so focusing on that, the more serious it is, of course, I think the more important it would be to ensure that it is vetted, whether it be by OPC or otherwise.
And the user would still have the opportunity to use the app or the operating system or whatever it is, that the cell phone coverage, if that's what they're signing up for. When they say opt out, they opt out of that aspect of it, but they can still have it, so they're not under duress of any type to sign up. Okay. We also have the case of the Tim Hortons app, wherein users were told the geolocation functions were only being accessed when they had the app open, but it was later learned that the app was the app was collecting the information even when it wasn't open. So, do you see the role of the Privacy Commissioner as having anything, again, to preempt such an aspect? And in particular with this one, nobody can cash in their points unless they download the app. So it's, okay, I can't have my points unless I give them access to this information.
Right, and I think your last comment, Ms. Gilland, highlights what was mentioned in this committee in the mobility study as being a culture of I agree, right? A culture of clicking yes to the policies because you want to use the technology, and I think this is part of it, making sure Canadians can use and participate in this digital technology, but not at the cost of their privacy rights. And so, in the Tim Hortons incident, what came out was that there was a concern in terms of the purposes. There was no legitimate need for all this information. It was very intrusive in the sense that it kept doing it even when the app was not in use, and it was doing it very frequently. There was a concern in terms of the consent. It was not, users had not been informed as to how extensive it was going to be, and they didn't understand that it would result in their location information being used in such an excessive way. But there was also concerns about the contract clause with the provider being too flexible in terms of how they could use it, and also in terms of the privacy accountability regime. So I think those are all areas where the Privacy Commissioner, with a proactive mandate, audit mandate, could have engaged and had discussions saying, but make sure that there's privacy by design here. Make sure that there's a privacy impact assessment that's meaningful. And so there's a role for the OPC. There's a role also for legislation in terms of mandating these types of accountability processes.
The OPC or legislation that would need to be put in place to require all the apps that are already out there and unbeknownst to us collecting information or having information sold without our immediate knowledge.
Well, the OPC will be able to do certain things based on authorities that it is given under the Act. And so I would start with the Act to ensure that if it is to require organizations to do such things, and if it is to allow the OPC to be auditing it, that would be the place to start.
Okay, thank you, Ms. Gallant. And now for the, I think what will be our last round then, Ms. Hefner for up to 5 minutes.
Thank you very much, Chair. And through you, I would like to ask Mr. Dufresne what you think about the idea of the concept of a single digital identity. So there's this idea that we could all have one Canadian national identity. We could have more control over our own information. But at the same time, some people are afraid that it would give the opportunity to have us tracked. So I'm just wondering if you could weigh in on that whole idea.
Right. Well, and maybe I should have mentioned that in terms of the earlier question about, from Mr. Green, I believe, in terms of future issues to look at. And so I think this is a good example in terms of I would want to learn more about the specific technical aspects of it. You had a discussion, I believe, with Mr. Terrien on that, and it came through that there is potential in that. There's potential as being very useful and very effective tool, and perhaps more so than SIN numbers and other such, but there are also risks in terms of privacy. So this is an example where you would want to have strong privacy impact assessment, ensuring how this is used, how safe it is, how the information is going to be contained. So again, reaching that public interest benefit, that benefit for Canadians, but not at the expense of privacy.
As a federal privacy commissioner, how do you expect that you would interact and work with privacy commissioners at the provincial level?
I would expect and commit to work very collaboratively with those colleagues. They do fundamentally important work, and there are some areas of parallels with PIPEDA. Certain provinces will be the provincial legislation, such as in Quebec, BC, Alberta. There's a strong need to collaborate with all of the provincial authorities, and we've seen it. There have been joint investigations, whether it's Clearview AI, whether it was the issue of Tim Hortons. So these are good examples. I think it's very important, not only for the exchange of expertise and knowledge, but also in terms of the impact. So I would look forward to continuing that, and I look forward to meeting all of them, hopefully after the confirmation.
Thank you. Earlier, I tried to bring a motion to this committee that looked at privacy of people working at home. There wasn't enough appetite on the opposition benches to move forward with that study, but there has been evidence that employers are increasingly surveilling employees at home. So with this change in sort of the way our society is functioning, how quickly could your office adapt to upcoming issues like privacy of people working from home?
I think that it's important for the commissioner, federal commissioner, provincial commissioners, to be at the forefront of these types of issues. So this is an example of something that's happening perhaps in the employment realm, so perhaps there's some provincial jurisdiction aspects to that, but it has an impact on privacy. And so new technology, new benefits, again, what are the implications and how do we minimize the impacts on privacy? So whether it may not be, again, depending on jurisdiction, it may not be the OPC that would be enforcing that, but I do see a role in terms of communicating and raising this issue. I think it's important to keep on top of these new evolving technologies, and I do see as part of my vision as the OPC as being a center of excellence for all things related to privacy.
Okay, with 1 minute left, I just want to take you back to what I think do I have 1 minute left? Yeah. What I think I've understood. So we've been talking, especially with the mobility data report, about informed consent. And what I think I'm getting from you today is that we move away from this idea of informed consent, take the onus off the user and put it on the legislation and the company. Is that what I understand? That because informed consent is so hard to properly get, maybe we don't put the onus on the user, we put the onus on the companies and the legislation.
There's always going to be a place for consent, and when consent is needed, it has to be meaningful. It has to be a consent that is informed, and the individual have to know what's happening and why, and have the ability to opt out. There may be such situations where it's not appropriate to have consent, and it should be rather something that is not permissible in terms of use. It's not a legitimate use. So we need both. We need a regime that says, see, there's certain no-go zones, there's certain things you can't do, even with consent. There's certain things you have to consent to, and there may be things that you're not going to be consenting to because there's such a public interest, public health, or it's not possible to have that. So it's a range.
All right, and with that, I don't see any other questions or anybody. Ms. Khalid, though, would you like the floor?
Thank you, Chair. I do have a motion to move. I move that the committee report the following to the House. Your committee has considered the certificate of nomination for Philippe Dufresne, a nominee for the position of Privacy Commissioner, referred on Wednesday, June 8, 2022, pursuant to Standing Order 111.1 Sub 1. Your committee has considered the proposed appointment of Philippe Dufresne as Privacy Commissioner and reports its recommendation that he be confirmed by the House of Commons as Canada's Privacy Commissioner.
The motion is in order. Discussion or debate on the motion? Is it the pleasure of the committee to adopt the motion? Any opposed to the motion? Seeing none, the motion is carried. So thank you to nominee Dufresne for coming today, and I will report this recommendation to the House as soon as I possibly can. And with that, meeting is adjourned.